Assalamu alaikum wa rahmatullahi wa barakatuhu.
Welcome back to Philippine Politics and Governance. Today, we will talk about the roles and powers of the Judiciary Branch of the Philippine government. The main objective of this lesson is for the learners to analyze the roles and responsibilities of the Philippine judiciary. Please do not forget to subscribe to our channel and like this video. If you have questions, please leave them on the comments section. Thank you. Judicial Power. The judicial power is the power to interpret and apply laws. The judiciary branch serves as the supreme arbiter, or judge-mediator of disputes on law and rights of citizens. The Supreme Court decides on the validity, legality, and constitutionality of newly approved laws. If there are matters with which legislative and executive cannot agree upon, the judiciary branch decides on these policies. They also hear and settles disputes brought before them. Whether it be on the district courts, regional trial courts or in the Supreme Court, they hear and decide on proper punishment for these cases. The judiciary branch also upholds the rule of law by determining violations and prescribing proper sanctions. And they protect the rights of the citizens in cases of disputes in contracts and agreements, and violation of constitutional rights. Just like how the President embodies the executive branch and the Congress embodies the legislative branch, the Supreme Court embodies the judiciary branch. The Supreme Court is the highest court in the Philippines. It supervises all other courts in the country. The Supreme Court also hears legal cases and render judgment on these cases. All courts in the country exercise power of original jurisdiction, which means hearing a case for the first time. However, only higher courts have the power of appellate jurisdiction. This means that higher courts can review and evaluate decisions made by lower courts after hearing and deciding upon a case. The Supreme Court, being the highest court in the Philippines, have both the power of original and appellate jurisdiction. Just like the executive and legislative branches, the judicial power has limitations. The Supreme Court cannot appoint its members. The Congress is the one that decides on the requirements for membership in lower courts. The Congress also constitutes the Commission on Appointments, which in turn sets the members of the Judicial and Bar Council or JBC. JBC then prepares the set of nominees for membership in the Supreme Court. The final authority in selecting and appointing justices of Supreme Court, however, still belongs to the President. Composition of the Supreme Court. As stated in previous lessons, the Supreme Court has 1 Chief Justice and 14 Associate Justices. The main tasks of the Chief Justice is to preside over hearings conducted by the Supreme Court. He or she also certifies the decisions made by the Supreme Court. The Chief Justice is also the chairman of the JBC and is the chief presiding officer during impeachment trials. Out of the 14 Associate Justices, there is 1 justice recognized as the Senior Associate Justice. The Senior Associate Justice acts as the presiding officer if the Chief Justice is absent. Membership in the Judiciary and the Supreme Court. One might wonder how one can be a member of the Judiciary Branch or the Supreme Court itself. The basic requirement is for an individual to possess either a Bachelor of Laws or Doctor of Laws and have passed the bar exams set by the Supreme Court annually, and of course, a practicing lawyer. The Congress sets the qualifications for membership in the lower courts and may vary from time to time. But, the requirements stated above are essential. When it comes to the membership in the Supreme Court, the JBC screens applicants based on these 4 components: competence, integrity, probity and independence, and physical, mental, and emotional condition. The competence is measured in the level of education and experience the legum baccalaureus or Juris Doctor has. JBC considers the educational preparation, experience, performance and other accomplishment of the applicant. The integrity shall be measured by performing background checks on the applicant's records and reputation for honesty, integrity, incorruptibility, irreproachable conduct and fidelity to sound moral and ethical standards. Probity and independence can be checked through evidences such as but is not limited to, decisions he has rendered if he is an incumbent member of the judiciary or reflective of the soundness of his judgment, courage, rectitude, cold neutrality and strength of character shall be considered. Physical, mental and emotional condition on the other hand, is analyzed through medical and psychological tests. An applicant should be of sound physical, mental and emotional health in order to perform tasks expected from a Supreme Court member. The Court of Appeals. This is the second highest court in the Philippines. It can exercise the power of appellate jurisdiction over decisions made by the regional trial courts. They also review administrative cases involving matters concerning the Ombudsman or the Department of Justice, as well as the decisions of government agencies with quasi-judicial functions such as the Office of the President. The Court of Appeals conduct an intermediate review of criminal cases with life imprisonment or death as penalty, before it proceeds to the Supreme Court. The Court of Appeals is composed of one presiding justice and 69 associate justices, which are divided into 23 divisions. Therefore, each divisions have 3 justices each. The lower courts. The lower courts are organized based on area of jurisdiction. The regional trial courts or RTCs are categorized into 13 judicial regions. The number of RTCs depends on the size or population of the province or city. The municipal trial courts or MTCs have jurisdiction over municipalities or towns. If 2 or more municipalities are covered by an MTC, then it becomes a municipal circuit trial court or MCTC. In the case of the cities in Metro Manila, the MTCs are referred to as Metropolitan Trial Courts or METCs. Specialized courts are under the Judiciary Branch as well. Sandiganbayan hears cases involving violation committed by public officials, with the exception of the President, Vice President, Supreme Court Justices and the Ombudsman. Sandiganbayan is composed of 1 presiding justice and 14 associate justices. The Office of the Ombudsman we currently know was established under the 1987 Constitution with the main task of performing checks on those in power to ensure that they do not abuse such power. It places a higher level of accountability for government worker based on the principle that public office is a public trust. Court of Tax Appeals. This court hears cases concerning tax collection. Cases on real properties and trades fees and fines are handled by the Court of Tax Appeals. It is composed of 1 presiding justice and 8 associate justices. The Sharia district courts and Sharia circuit courts have jurisdiction over Muslim-majority Bangsamoro and some other parts of Mindanao outside of the autonomous region. The SDC has equivalent power as to RTCs, while the SCC is roughly equivalent to municipal courts. There are 5 Sharia district courts in the country. They can be found in Halo Sulu, Bongjao Tawi, Zamboanga City, Marayan Co Tabato City. Quasi-judicial bodies are also under the Judiciary Branch. Quasi-judicial bodies can exercise judicial powers but only within its jurisdiction. For example, the Office of the President can perform inquiries within its offices. The National Labor Relations Commission or NLRC is one example of a quasi-judicial body. It is under the Department of Labor and Employment. It hears cases concerning employer-employee relations. Another example of a quasi-judicial body is the Department of Agrarian Reform Adjudication Board or DARAB. This agency is under the Department of Agrarian Reform which hears and resolves cases regarding agrarian reform. Due process and jurisprudence. The concept of due process maintains fairness in all judicial processes. The main purpose of having and following due process is to recognize and protect the rights of an individual involved in a case, whether it's the complainant or the accused. In the judiciary system, precedence is of big importance. Precedent is the principle or rule established by an original or previous legal case which then defines subsequent rulings in other cases. For example, when a plan of defense is used in a recent case, and has been used in a previous case, this can be used as legal basis as to declare the innocence or guilt of the accused. Jurisprudence, on the other hand, refers to the study of the nature of laws. Originating from the Latin word juris and prudential, which means law and wisdom or knowledge, respectively, jurisprudence is the philosophical study of the meaning of law rather than the study of the legal system. Criminal procedure. This is a summarized steps for criminal procedure. First, there should be a complaint. The victim or a member of his or her family, or even a friend, should file a formal case or complaint to the police. Afterwards, a preliminary investigation will be made in order to put up a case to be submitted to the prosecutor. The prosecutor then reviews the case from the police and starts his or her own investigation to justify that a crime has indeed took place. The prosecutor updates and prepares the case to be submitted to either the MTC or RTC. MTC or RTC will then evaluate the case if the case is viable. If the case contains insubstantial or insufficient evidences, the case will be dismissed. Otherwise, the judge will issue an arrest warrant for the police to get the accused and place him or her into custody. Once the accused is in custody, he or she have two rights: the right to counsel and the right to bail. The accused is advised to hire a lawyer. If he or she cannot afford a lawyer, the government will provide one. The right to bail, on the other hand, is quite different. Depending on the offenses the accused is being charged of, the amount of bail may vary. Even the right to bail may not be granted in capital offenses such as murder, or an offense punishable by reclusion perpetua or life imprisonment are not bailable. If the accused is granted bail, he or she will have to pay certain amount to secure release from custody. However, the accused is required to attend the arraignment and trials as scheduled by the court. Rights of the accused. The rights of the accused are explicitly stated in the Revised Rules of Criminal Procedure, Rule Number 115. However, basic human rights are also applicable, such as in Article 3, Section 14 of the 1987 Constitution, no person shall be held to answer for a criminal offense without due process of law. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. The following are the rights of the accused as stated in Rule Number 115. Section 1. Rights of accused at trial. In all criminal prosecutions, the accused shall be entitled to the following rights: I. To be presumed innocent until the contrary is proved beyond reasonable doubt. B. To be informed of the nature and cause of the accusation against him. C. To be present and defend in person and by counsel at every stage of the proceedings, from arraignment to promulgation of the judgment. The accused may, however, waive his presence at the trial pursuant to the stipulations set forth in his bail, unless his presence is specifically ordered by the court for purposes of identification. The absence of the accused without justifiable cause at the trial of which he had notice shall be considered a waiver of his right to be present thereat. When an accused under custody escapes, he shall be deemed to have waived his right to be present on all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his rights without the assistance of counsel. D. To testify as a witness in his own behalf but subject to cross-examination on matters covered by direct examination. His silence shall not in any manner prejudice him. E. To be exempt from being compelled to be a witness against himself. F. To confront and cross-examine the witnesses against him at the trial. Either party may utilize as part of its evidence the testimony of a witness who is deceased, out of or cannot with due diligence be found in the Philippines, unavailable, or otherwise unable to testify, given in another case or proceeding, judicial or administrative, involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him. G. To have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. H. To have speedy, impartial and public trial. I. To appeal in all cases allowed and in the manner prescribed by law. That is the end of the lesson. Thank you for watching. In the next lesson, we will discuss the roles and functions of the local government unit. See you there.